Welcome everyone, and thanks for joining us. We're excited to spend the next 30 minutes or so giving you an overview of estate planning concerns that are common to millennials and how millennials approach estate planning a bit differently from prior generations. Then we'll have some time for questions at the end. You can ask questions throughout the webinar in the Q&A module or on the Contact Us form. Some other quick housekeeping items before we get started. There are handouts in our bios on the resource list if you're interested, and the slide window can be made larger by choosing the full screen button. So with that, we'll introduce ourselves. I'm Wrock, and I work primarily out of our Ann Arbor office.
I'm Janelle Haggadone, and I'm based in the Grand Rapids office.
And hopefully you can tell by our photos that we're both millennials.
Now we want to give you a brief outline of where we're going. We'll start with an overview of the millennial generation, exploring sources of our risk aversion, describing what we value, and how our lifestyle choices differ from previous generations' choices. Next, we'll talk about basic estate planning documents every millennial should have in place, including millennials with children, whether pet or human, and the documents millennials without any children should have in place. We'll touch on the distinction between private loans and public loans, and we'll talk about repayment options. We'll talk about digital assets you may have and you may want to plan for. And then we'll talk about ways to ensure that your estate plan has the social impact you want it to have. Finally, we'll wrap up with a discussion of tangible personal property. I should note that our presentation today will be limited to Michigan law, but if you're looking for Florida estate planning advice, you can also contact Rebecca about that because she's licensed there as well.
So there are some key characteristics that define us as a generation, and these characteristics, of course, have an impact on how we approach life decisions, including estate planning. We highly value instant access to information, instant gratification, and technology. If we don't know the answer to something, we at least know where to start looking. We're active on social media and value maintaining our web presence, which ties into being connected with others. And many millennials have some or a lot of student loan debt from attending school during the era of drastically rising tuition rates, in some cases coupled with a really tough job market for those millennials who entered the workforce during the recession. The student loans in the recession, coupled with other formative life events like 9/11, have caused many millennials to be risk averse.
Along with being risk averse, millennials are also socially conscious and community oriented. But we might not be able to make the same charitable contributions that our parents made. So instead, we might opt to patronize and work for companies that are not only customer-oriented, but those that have socially oriented mission statements. Maybe we spend a few extra dollars on a pair of shoes if a company uses some of its profits to provide shoes to economically disadvantaged individuals, for example, because millennials are always looking to make a difference. Additionally, millennials prioritize experiences over products. We're less likely to save our money to purchase a car and are more likely to have a travel fund to use to book last-minute flights. Millennials will also invest in themselves, and we're spending more money on our own education than previous generations.
We're also delaying buying a first home, getting married, and having children, though because of this we have a lower divorce rate, which is lowering the divorce rate of the general population. And more often than prior generations, millennials are choosing not to have children for a variety of reasons. Millennials are starting businesses less frequently despite being entrepreneurially minded, and this goes back to the risk aversion. We also value convenience, personalization, sustainability, collaboration, being inclusive, community-oriented, and empowered. We want to understand and be involved in decisions that affect us and those we care about.
Millennials are also taking charge of their own health. For many of us, health and wellness is a daily active pursuit. Millennials eat healthier, smoke less, and exercise more. Almost half of us consider healthy eating a lifestyle choice rather than using dieting to shed weight ahead of a vacation. We also use apps and technology to stay healthy. And although we're earning less than older generations, we're spending more on our health and fitness. Additionally, about 20% more millennials than our Gen X and baby boomer counterparts view work-life balance as a major career concern. Millennials are also more likely to value finding a calling or a purpose rather than succeeding in a specific career. Many millennials also have a side hustle or two to help supplement their incomes. You surely have at least one millennial friend that has, or at least has attempted, to monetize her Facebook page by selling fitness shakes.
So the basic documents that everyone should have, including college students and high school students over 18, are the Durable Power of Attorney and Patient Advocate designations. The Durable Power of Attorney lets you name an agent to act on your behalf with respect to finances and legal decisions, and the Patient Advocate designation lets you name a patient advocate to make medical decisions for you if you cannot, including end-of-life decisions. Without a Durable Power of Attorney, someone would need to take the time and expense to go to probate court in order to be appointed as conservator, which would let them deal with your finances, and it may not be the person you'd want. Same thing with the patient advocate designation. If you don't have one, someone would have to be appointed guardian by the probate court to make medical decisions for you, and it may not be the person you would choose. So this is important, being millennials, when you're traveling, maybe you're doing your gap year in Europe, or you're off in Bali or something, and you're trying to get that epic selfie on the side of a cliff and you fall off. You want your parents or someone else to be able to make decisions for you, both for medical and financial, without having to go to probate court first. Trusts, wills, and other planning can be assessed case by case, and we do recommend making that decision with an attorney because there are a lot of factors involved. To start, you may be wondering about the differences between wills and trusts, what types of assets and situations would make a trust really beneficial, and what happens if you don't do any planning. And Janelle's going to talk about that next.
You might be getting to the point in this presentation where you're wondering, what's the worst thing that can happen if I don't do an estate plan? Well, what will happen under Michigan law is intestacy will take over. Intestacy is a fancy way of saying an estate in which a person died without signing a valid will or other binding document, such as a trust. You'll see that as the third row on our chart here. As you can see, under intestacy, you don't get to decide how your assets are distributed. You don't have continued control over those assets after your death. It doesn't stay private because you're in the probate court. And your family members will be having to deal with the probate court. Now, a will can address some of these problems because at least you can determine who you want the beneficiaries to be and who you want the personal representative to be. But it will not permit you to continue to have control over assets from the grave. So your beneficiaries would receive a lump sum check regardless of their ability to responsibly manage money. Additionally, both if you die intestate or if you die with a will, your personal representative will need to interface with the probate court. As you likely gathered from the ongoing drama surrounding Aretha Franklin's estate, for example, these court proceedings are not private, so people will learn about your personal affairs after your death. A trust, however, can address all of these concerns. But generally, just so you know, we prepare a trust in conjunction with a pour-over will. You can determine with a trust exactly who will receive your assets, when they'll receive them, and for what reasons. You get to determine who is in charge, and your trust does not need to be filed with the court. Beneficiaries, although they're entitled to receive certain information about the trust, don't need to receive copies of the entire trust. So if you have your reasons for leaving your cousin Sasha $1,000 and your other cousin Malia $500, then they don't need to know that. You'll also save your loved ones from needing to deal with the probate court. By the way, as a thank you for your attendance today, you can access a takeaway piece we've prepared for you called Do I Need a Trust? This is a decision tree, and you can use it in conjunction with your estate planning attorney to determine if you need a trust. You can find it in the resource list, but it will also be included in a follow-up email you'll receive from us later. For millennial parents, having children is the most common reason they decide to create an estate plan. Specifically, millennial parents are often most concerned with naming a guardian and a conservator to care for their children in the event that they die before their children become adults. This is one of the harder decisions millennial parents need to make. The guardian is the person who would provide shelter, love, emotional support to the child. The conservator is the person who would control money that the child would receive, outside of any money a child would receive as a trust beneficiary, which would be controlled by the trustee. Factors to consider when choosing this person or people, because one person can serve as guardian and another as conservator, if you think that's most appropriate, include whether that person has an existing personal relationship with your child, whether the proposed guardian and conservator would be willing to accept the role. You should have a conversation with those people ahead of time. Whether the guardian and conservator are in good health, and also you want to consider their existing family situation. Specifically, you want to think about whether you're comfortable with that person's spouse having an influential role in your child's life. Also, you should consider the fact that if your child is 14 years old or older, they can object to the appointment made in your will. So if your child wants to finish high school and the guardian and conservator live in California, the probate court may decline to follow your designation. As alluded to above, in addition to naming a guardian and conservator for their children, many millennials decide to include trust in their estate plan so that they can specify when and how children will receive inheritances. Instead of accumulating wealth just for the sake of passing money down to the next generation with no strings attached, millennials prefer to pass down money in a way that incentivizes their kids, and sometimes even their grandkids, to pursue education without taking on burdensome student loans that they have carried or that they might still be carrying themselves. They also want to keep a reserve of money in trust for their children so that they can buy a home, start a business, and travel. Trust can also be created in ways that protect children from creditors, such as a child's spouse who files for divorce, and also from predators. They also want to protect their children from themselves. As we know now, a child's brain isn't fully developed until their mid-20s, so giving an 18-year-old a lump sum of cash won't lead to the best decision-making. Your estate planning attorney can help you create a plan for providing for your children that addresses your specific concerns.
If you don't have kids, you don't have to worry about leaving anyone an inheritance, but you're also likely to have more money to leave someone an inheritance, relatively speaking, since you don't have the associated cost of paying for children, which we all know amounts to quite a bit. You might also be spending your money on travel or other pursuits that are a little bit riskier, perhaps, and really necessitate those lifetime documents that we talked about at the beginning. You might want to leave money for the care of a pet, which we'll talk about next, or for other relatives like your parents, siblings, or nieces or nephews. You might also have a charitable cause that you care about and want to benefit with your estate. So whether you have kids or not, pets are increasingly recognized as members of the family, particularly among millennials. We've adopted more animals than any other generation, spend more money on them, and for many of us, they're our children. But while there's a trend towards treating pets more like children in some ways, for example, a few states allow the best interest of the pet to be considered in a custody dispute, they're still personal property for now. This means that if you don't make a plan for them, their future can be decided as casually as someone decides what will happen to your couch. And if you don't plan with a trust, the pets could be in a shelter with an unintended caregiver or euthanized by the time your probate estate is even filed and in front of a judge. A pet trust fixes that. It can be a separate document or a part of your trust, and what I like most about it is that you can name a succession of caretakers rather than just one caretaker. It gives you control to say, Emily's the caretaker, but if something happens to her, then the next caretaker is Mike, rather than leaving that decision up to Emily, because she may not make a decision, and now your pet would be a part of her probate proceeding. Or if she does make a decision, it might be someone you don't want or someone you don't even know. With the pet trust, the pet is actually the beneficiary, not the caretaker, so the funds have to be used for the pet and as you instruct. If something happens to the pet caretaker, the next caretaker is someone you have already nominated, rather than leaving that decision to the hands of someone else. And if there are any funds left over after a pet's death, clients will often choose to leave those funds to an animal-related charity in memory of their pet or to their other beneficiaries.
Another defining characteristic of the millennial generation is that we carry a lot of student loan debt. When talking about student loan debt, it's important to figure out what type you have. If you have private loans, you probably know there are really no options for deferring them. You can't forbear them. There's no forgiveness, generally, not even after your death. For federal loans, however, they generally are forgiven when you die, but they can't be discharged for a reason of bankruptcy, and that's the same for private loans. But if your federal student loan is forgiven upon your death, you need to be aware about the cancellation of debt income issue. The Tax Cuts and Jobs Act of 2017 eliminated income tax on the cancellation of debt income, but this change and many others are due to expire at the end of 2025 unless Congress acts. If Congress doesn't act and you have substantial federal student loans, you might want to consider purchasing enough life insurance to cover the income tax on that cancellation of debt income. What this means is that if you owed $200,000 when you die, your estate would be responsible for paying income tax on that $200,000, meaning less money is going to go to your intended beneficiaries. Another thing to think about with federal loans is that there are various options for deferral or forbearance in times of hardship, and there's a few different repayment plans you can choose from, which Rebecca will discuss next.
So there are several options for federal student loan repayment, and the standard is the default, which is 126 monthly payments over 10 years. So they would just look at whatever your loan balance is and then divide that out over the 120 payments to arrive at your monthly payment. The income-driven repayment is IBR, ICR, pay, and repay, and those stand for income-based repayment, income-contingent repayment, pay-as-you-earn, and revised pay-as-you-earn. And they're all a little bit different, but each of them are calculated based on income, and the payment cannot exceed what it would be under the standard repayment plan. So if the payment under the standard repayment plan is less, that is the payment that you are stuck with. They have 10 to 15% of your discretionary income for 20 to 25 years, depending on the program, and the 10% in 20 years is typically reserved for undergraduate loans, whereas the 15% in 25 years is typically for graduate loans. There are some possible interest subsidies, and not all borrowers are eligible for all programs. As Janelle mentioned on the previous slide, but bears some repeating here, the cancellation of debt income would not apply to these for the time being if it's due to death, if the loans are forgiven due to death. But if they're forgiven during your lifetime because you've made your 20 or 25 years of qualifying payments, the cancellation of debt income does apply. So you would want to plan for that, know that your tax bill is going to be higher that year, potentially your bracket might even change, and in some cases it could be quite a lot added to your taxes. One program that does not have cancellation of debt income during your lifetime is public service loan forgiveness. So this program, your payment would be the same as under the income-driven repayment, but the balance is forgiven tax-free after 10 years. So the qualifying 120 payments while working full-time in public service would get that tax-free forgiveness for you, and that would be a 501c3 nonprofit, government, or some other public service qualifying jobs. And full-time is the greater of whatever your employer considers to be full-time or 30 hours a week.
Millennials are considered the first true digital natives, and as such, we have a lot of digital assets. Social media, apps, electronically stored data, airline points and loyalty programs, and many financial accounts are exclusively online with no physical branch location. Other digital assets include blogs, websites, photos and videos, smartphones, and clouds where we store all of this digital stuff. There are a lot of options when it comes to planning for digital assets, but here are a few things to consider doing now. First, you can keep a secure list of usernames and passwords and corresponding instructions for each. You can use popular password vaults like LastPass and 1Password. If you've created a trust, you can consider whether you want your trustee in charge of your digital assets, and if so, what level of access should the trustee have? Maybe it makes sense to make your agent under your durable power of attorney the person in charge of your digital assets. Maybe you want a separate digital assets plan altogether. Digital assets can change more frequently than other types of assets, so it might make sense to address those in a separate document. You can also look at Facebook Legacy Contact and Google's Inactive Account Manager. Online tools such as these function like a beneficiary designation does, because these tools would supersede any contrary instructions contained in your estate plan. If you have cryptocurrencies or password vaults, you should consider leaving the password in a safe deposit box to which the intended beneficiary or trustee would have access. One thing to note is that if you don't specifically give your agent power to have control over your digital assets, they won't be able to get that power even if they obtain a court order.
Being socially conscious millennials, a lot of us want to make a difference in this world and are really invested in social causes. Yet, with student loan debt and some other hurdles our generation has faced, not everyone has the resources to make an impact in the ways you might typically think of doing, or like our parents did, for example, with larger charitable donations. But your estate planning attorney can help you come up with creative solutions. For example, you might establish a 501c3 nonprofit for a worthy cause, and you might be able to get the public service loan forgiveness we just talked about too. You could plan to benefit charities with life insurance proceeds or with your qualified retirement plan, which has tax advantages when paid to a charity because charities don't pay income taxes. You might look at social impact investing, which is where you tell your financial advisor that you want to invest in certain causes, for example, eco-friendly causes, and then stay away from other causes that you would consider harmful. You might look at eco-friendly options for what happens to your body after your death, like a green burial, which is where you just get buried in the earth with a wooden casket or shroud instead of with cement vaults and embalming. There are so many options, and these are just some examples of ways that you can make a lasting social impact with your estate plan.
The last substantive topic we'll cover today is tangible personal property. Tangible personal property is all of your stuff. We're talking about furniture, artwork, that collection of Beanie Babies gathering dust in your mom's attic, Pokemon cards, and other collections. And you might be less concerned with the monetary value associated with your stuff than previous generations. Items are more likely to have important ties to your memory instead of just a monetary value. If you do want to be sure that specific items are distributed to certain people upon your death, you have a few options. You can list those items in a will or a trust, or you can refer to a separate list in either of those documents that you can update periodically. If you opt for the separate writing, the writing must be either in your handwriting or signed by you, and must describe the items and the people to receive the item with reasonable certainty. You'd also have to list the items in a will or a trust with the same level of specificity.
So as we mentioned in the beginning, we understand millennials at Varnum. We have several millennial attorneys as part of our estate planning team, and both within the estate planning team and the wider firm, we have experts to plan for whatever is most important to you. We appreciate that you want to understand your choices, be involved in decisions, have customized and personalized service, be able to communicate with us quickly and conveniently, and have cutting-edge technology and resources available. You can find more information on our website at varnumlaw.com, or please feel free to contact either of us directly. We're available throughout our 8 Michigan offices in Ann Arbor, Birmingham, Detroit, Grand Haven, Grand Rapids, Kalamazoo, Lansing, and Novi, and we'd love to help you achieve your goals.
Thanks to those of you who are sticking around for the Q&A session. We've received a few questions so far, so keep submitting them. If we run out of time to answer your question, we'll follow up in a separate email. First question we have, my parents are divorced and my dad's getting remarried. I'm worried that my siblings and I are going to be cut out of my dad's will, and I'm thinking of bringing it up with him. Are there any options I should mention?
Yeah, so we definitely recommend that your father consider doing a prenuptial agreement before getting married. Under the law, spouses are entitled to a certain portion of the estate unless the spouse has signed those rights away in a binding marital agreement. And I understand the concern because in a lot of cases when the spouse gets money, that money is diverted over to his or her own family on the surviving spouse's death. So after doing the premarital agreement, your father should create or update his own trust afterwards to specify his wishes. We regularly plan for blended families, and depending on the situation, there are some additional options he can consider, such as naming you and your siblings as beneficiaries of an account or of life insurance proceeds, with or without an irrevocable trust. He could also gift money to you and your siblings during your lifetimes. There are a lot of options to plan for blended families, and these are just a few. One thing to note is that if you have a step-parent or step-sibling that you would want to receive your assets, they won't be entitled to receive anything under the law, so you have to affirmatively plan to include them. And by the same token, you aren't entitled to receive anything from their estate under the law, so they would have to affirmatively include you in their plan as well. So our next question, I added my sister to my bank account because I wanted her to be able to access money if something happens to me. I'm also okay with her getting the money if I die. I don't really have any other assets right now. Do I really need to do anything more than that?
Okay, well, a couple things to note. At the time you added your sister as an owner, as a joint owner to your account, you made a gift. So you could be on the hook for paying a gift tax on that depending on how much money was in your account. Also, because it's a joint bank account, you're both owners. So if your sister gets sued or has another creditor, that creditor can access the funds in your bank account. You said you don't have any other assets, so you're actually in a pretty risky position. You might want to consider opening another bank account that your sister's not a joint owner on, that might hold the bulk of your money. But of course, then you're left with an asset that would go through probate, which could also happen if on your current account your sister predeceases you. So I think some additional planning should be a priority for you. All right, next question. Actually, Rebecca, do you want to ask this one?
Yeah, so I have more student loan debt than I would like to admit, and I'm thinking after listening to this that I need to get some more life insurance to cover that. Can you help me?
Okay, well, we can't help you with actually signing you up for a life insurance policy, but we do have really close relationships with sophisticated, responsible advisors all across Michigan, so we'd be happy to connect you with one of them. We service our clients best when we work closely with their team of professional advisors, so we're looking forward to connecting you with the right person to address your needs. Next question is about pet trusts. So Rebecca, we're going to give this one to you. Is it possible to set up a general pet trust now that would take care of my dog if I were to pass away during his lifetime, but that would also cover any future pets in the event I pass away after he's gone?
So the answer to that is yes. When we draft pet trusts, we typically draft them to cover all animals that you own at your death, which, depending on when that is, would be pets that you own now or pets in the future. I also name pets that you own currently, so I'll call them out by name, and then as time goes on, if you want to update your pet trust to include names of future pets, you can certainly do that. But we also always include all pets that you own at your death, so everyone in the future is covered. So next we have, I am named as personal representative of my mom's estate. What do I need to do and when?
Well, your authority as personal representative won't begin until your mom has passed, and more specifically, you'll need to obtain letters of authority from the probate court before you can act as personal representative. But one thing you should do now is find out where she keeps that original will. Sometimes you might hold on to your own original will, so your mom might have it in a fireproof box or in a drawer or in a binder somewhere in her house, or the attorney who prepared it might be holding on to the original. We often do that for our clients and hold it in our own vault. So find out where that is located. Then after she has died, you want to take that original will and file it with the probate court located in the county where she was residing at the time of her death. You'll take care of paying final expenses, including any medical bills, any taxes that have become due. You'll want to file final tax returns, and then you want to pay any fees that are due to attorneys that have assisted you with the administration. And then finally, you'll follow her wishes in the will and divide up the remaining assets as she provided, unless she has a trust that takes care of that. We should mention that we do offer estate and trust administration services, so we'd be happy to assist you when the time comes with performing those tasks and duties. Next question is about electronic wills. Can I write a will on my iPad and sign it electronically?
So we don't recommend that. As Janelle said earlier, a will is in probate court, so one of the issues the probate court would have to decide is whether that will is valid. So that's to say, does it meet the formalities required for executing a will? How much proof is there that you're the one who wrote it? And does it reflect your intentions? There was a recent case in Michigan where the individual typed out a note on his cell phone disinheriting his mom right before dying by suicide. And the court held that it was his will based on the surrounding facts. But again, you'd have to have that decided by the probate court. Another issue is that if it's not a holographic will, which means a will that doesn't necessarily have to be witnessed because it's in the handwriting of the person who made it, an electronic signature could be compared, but the handwriting wouldn't be there to be compared. So it's not as easy to tell whether that was something you actually executed yourself. And then just a side note, some other states don't accept holographic wills even if they're executed in a state that does accept them. Next question. I am remarried, and can I name my spouse as guardian and conservator of my children if I die? My children's dad still has his parental rights.
Okay. Well, you can name your current spouse as the guardian and conservator. However, you won't be able to skip over the natural parent's right to parent his child. So your ex is still going to, be able to parent if you die before your ex does. But if your ex ends up saying, no, I don't want to take care of my child, then likely the probate court's going to get involved, and then maybe your current spouse will be appointed. But there's no way where you can just skip over the biological parent if they still have their parental rights, which you said they did. Okay, next question. Can I just use an online service for my will or trust? It seems to be a lot cheaper.
So it is, but we don't recommend this either. That ends up typically being a situation of you get what you pay for. So in some cases it can be better than nothing. You're really just answering a series of questions that is going to output a certain response. So when you work with an attorney, you have the benefit of his or her suggestions for a given situation, and based on the attorney's past experience working with a lot of other clients, a lot of individuals, a lot of families. So while it does cost more, you're receiving that customized and personalized service that's going to take into account all of the nuances involved with your situation and goals, as well as the documents to put that plan into place. When you use an online service, you're interfacing with a computer instead of a person, and there's not a lot of room for customization or nuanced situations, aside from fill-in-the-blank responses. So for example, your attorney is going to understand family dynamics and be able to make recommendations, and a computer is just not at that level. It's not going to know how to interpret that open-ended question and not necessarily even going to ask that question in the first place. So it can kind of be a situation of you don't know what you don't know, and the attorney is there to help you understand that and point out those situations. So next we have, I bought a home before my wife and I got married. She wants to get her name on the deed. Is there a good reason to do that?
Okay, there's a few good reasons to do that. If you were to die without an estate plan, whether your wife is going to get all of your assets is going to depend on whether or not you have kids, so we need more details to accurately analyze exactly how all of your assets are going to be distributed. But we do know that if you have no estate plan and your wife's not on the deed to the house, your house isn't going to get transferred anywhere if it's just in your individual name without dealing with the probate court. So you have a few options. You can create a trust and then put your house into the name of the trust. Then the trust would be the owner of the house, and the trust never dies. You could make your wife the beneficiary of your trust, and then she would, continue to have the home, access to the home. Or you could execute a deed that would move the house into both of your names as husband and wife, or as husband and husband, or as wife and wife. This is a particularly strong way to own real estate in Michigan because you have really strong creditor protection. For example, even if there's a creditor you owe money to, that creditor won't be able to reach the house because it's owned by a married couple, a special type of ownership in Michigan called tenancy by the entirety. So there are definitely some good reasons to change the way that house is owned. Next, we have this question about airline miles. Can I give my airline miles to someone else when I die?
So that's a big, it depends. It depends on the program, it depends on what the rules are at the time of your death. In general, airlines consider miles not to be a property right until a ticket is actually booked and used, essentially converting it into something of value. So each program is different, and you'll have to read the terms and conditions of whichever program you have. Some explicitly state that they can be transferred to anyone for a transfer fee, of course, but in some cases they can only be transferred to a surviving spouse, just as an example. They are subject to change at any time, so even if the rules say something now, they might say something else later. Some others state the miles expire when the account holder dies, but in all of these cases that I just mentioned, rumor is that exceptions are often made in these situations if you get the right customer service representative on the phone, and they'll often work with families, especially if there's something in the person's estate planning documents that says that they have a plan for those miles or what they intended for them, what they would like to have happen. We like to add that to our documents if we do have clients with substantial miles balances to sway that decision in that direction if possible. It's not guaranteed, but it doesn't hurt. In any case, we would suggest not closing out the account until the miles are transferred if they can be. All right, it looks like that wraps up our time for today. Thanks everyone so much for your thoughtful questions and for taking the time to listen to us. If we didn't get to your question, again, we will respond with a follow-up email, and feel free to contact either of us directly if you come up with additional questions that were not asked during the webinar. We would love to help you.